Good afternoon to those of you who have logged in very punctually. We'll be starting the webinar at 1 minute past 1 or thereabouts. Good afternoon to those of you who are joining. It's turned 1 o'clock and we'll be starting the webinar at about 1 minute past the hour. It's just turned 1 minute past 1, so we will now start the webinar. The meeting is being recorded. So good afternoon, and on behalf of Trust Mediation and my fellow mediator and director, Andrew Hannam, welcome to How Do You Say No to Mediation in Personal Injury and Clinical Negligence Claims. The title refers specifically to mediation. Much of what we say today will relate to other forms of ADR also. Housekeeping, as mentioned, we are recording this session. Recordings of webinars are posted on the Trust Mediation website a few days after the webinar. Questions, you'll see on your screen, I hope, a Q&A button. We very much welcome your questions. Please feel free to ask questions at any time. We will have a session at the end. When putting your question, you may state your name or remain anonymous as you prefer. Case law, we're covering some case law today, and this is relevant if you are offering ADR, persuading the other side to go to ADR, refusing ADR, dissuading the other side from going to ADR, as well as advocacy in court when dealing with ADR as part of the case management process, and also, of course, highly relevant to your case strategy. Important note, you and your colleagues and junior colleagues in particular need to be on top of the case law to avoid a cost risk or to set up such a risk. The case references, citations appear on the slides, and if you would like copies of the slides, please email, and I'll give you the address, which is also in the chat, email training@trustmediation.org.uk and put training in the subject, and happily we'll send you the slides. Defendant's perspective. Last month's webinar, we took a look at mediation and Churchill orders from the claimant's perspective. Today, we're looking at the same subject, mediation orders, from the defendant's perspective. And this is in accordance with our even-handed approach as independent neutrals. Later on, we shall ask for your observations, thoughts and feedbacks on what we believe will be a growing number of court orders for ADR. So we'll come to that, but meanwhile, please don't hesitate to put any of them into the chat. I'm going to start the slides which we have for you with looking back something like 40 years or so to a Law Society conference I attended. I think it was in Edinburgh, and one of the speakers on litigation was Bill Park of Linklaters. And what he said stuck with me for all of my time as a litigator and a mediator. And he explained how whenever he got a new case into the office, he would open two files. The litigation file, self-evident what that is for, but also the settlement file. And his first step on the settlement file was to phone, or if they were local, go and see the other solicitor to start a relationship, which he knew was going to be important as the case progressed. I think his advice back in the 1980s applies just as well today, except we might now label file 2 as a dispute resolution, and that will involve, as well as negotiation and Part 36 and the other traditional approaches such as JSM, will also involve consideration of mediation, neutral evaluation, and other forms of ADR. Each file, of course, is of similar importance to your client, and sometimes, because of court deadlines, pressure of work, and so forth, we get very focused on file 1, but file 2 is of equal importance to your client. So that's the blast from the past. Let's get up to date and look at what's happening in mediation today. These are some stats from the figures that we keep, and it's very interesting to compare the movement since 2017, when the NHS resolution scheme started, to the 2024. And you will see the 2017 line pre-issue, 27% of our mediations were pre-issue. That figure had risen to 51% by 2024. And we've noticed in some quarters recently that that figure can go as high as 60% of mediations taking place pre-issue. The central column pre-CCMC, the figure was 29% in 17, now 61%. And similarly with value, I think when the scheme started in 2016-17, there was a thought that mediation might be useful for those low value cases, often involving high emotion where there was a fatality or something of that nature. But you will see from the second set of stats that in 2017 we had 17% of our cases with a value in excess of 750,000. By 2024, that figure had risen to 47%. Another interesting set of stats here, comparing 2024 and 2025, and these tell us who's instigating the mediation. We have to take these stats with a pinch of salt, because sometimes it may be a defendant conversation will instigate, but it will be the claimant who contacts us. So these figures are from who contacts us first. But if you note the bottom of the first table, court ordered mediation in 2024, 0%, 2025, 9%. We fully anticipate that figure to grow. Also looking at the case types, you will see that in 24, 3% of the mediations we did were personal injury. That has risen in 25 to 15%. So some interesting pointers there on the way things are going. This is the list of the issues which Andrew and I will be dealing with today and then going on to discuss. The last bullet point is your views, and again I invite your questions or thoughts into the Q&A, and we'll be happy to deal with them at that point. A disclaimer, it would be misleading indeed if we were to give the impression that the cases referring today were an accurate and comprehensive view of the case law on this subject. Most certainly they are not, and hence the emphasis on disclaimer. The cases here, they do include some of the leading cases, but they're merely samples from the voluminous case law. That really sets the scene for our discussion, but I'm now going to turn over to Andrew. Andrew, if you would like to take it from here, please.
Yes, thank you, Tim, and good afternoon, everyone. I thought it was quite interesting when we look at ADR. Two ways to approach it. The slide, we phrased it as which end of the telescope are you viewing it from? Are you asking whether ADR is appropriate, or are you asking whether it's inappropriate? Our view, perhaps not surprisingly, and I think we are in line with the judiciary, is that most cases will be appropriate. There are, of course, some cases where that's not the case. So, for example, if a precedent does need to be set, if an injunction is required, it's beyond the scope of mediation, or there may be some other reasons. But as I think this presentation will hopefully demonstrate, the issues now have become much more nuanced. So the questions really are more, what form of ADR is appropriate, and is ADR appropriate at this time? So interesting, hopefully, that sort of slightly more nuanced approach to the question of ADR. Just looking at pre and post Churchill. Churchill, of course, was a real watershed case where specifically the previous leading decision of Halsey was overturned, and the court in Churchill made it very clear that the court does now have the power to be proactive in relation to ordering ADR. One of the key issues in Halsey, which had been relied upon, or people had used as a sort of get out of jail, was by simply sitting on a request to participate in ADR and not answering. Well, Lord Justice Briggs in the case of PGF made it very clear, and this point is still being reiterated in cases today, is that you cannot be silent, and that silence in the face of such an invitation is likely to be considered as unreasonable and probably will be visited by a cost sanction. There are cases when it has been considered reasonable to say no to mediation. Two cases that we've extracted to illustrate some of the arguments that might be successful. The first case that you'll see on the slide there is Uag, probably not how it's pronounced, but that will do for today, where the court concluded that the defendant's refusal to enter into mediation shouldn't count against him, as it would have been likely to have been unsuccessful and led to a waste of time and expenditure. We'll see how those observations have been revisited as we look at some later cases. 2017, the case of Gore and Nahid, Lord Justice Patten said that he had some difficulty in accepting that the desire of a party to have his rights determined by a court of law in preference to mediation can be said to be unreasonable conduct. And that comment was made at a time when the defendant had been successful in defending the claim. We then get Churchill, which, as I said, we see as very much a watershed. And the trend in cases since Churchill has become increasingly pro-ADR. A very interesting case, which is well worth a read, is the case of DKH Retail. Perhaps one of the most, or there are 2 points, I guess, that stand out from DKH Retail. One, the request for a mediation came very late in the day, only months before the trial, and the court indicated that, albeit late in the day, it was still going to direct that mediation take place. And the other important issue that was addressed in that case was the suggestion that the requesting party were bound to lose, and on that basis, the party opposing the request for an order for mediation, their argument was dismissed. A couple of interesting lines of cases where, and again, this is a trend which appears and is discussed in a number of the leading cases about mediation, is that the courts are perfectly prepared to contemplate mediation occurring more than once during the lifetime of a case. And that's something that's interesting and worth bearing in mind. There are cases post-Churchill which are interesting. The Northumber case, I just want to take a little bit of time to talk about because I found that particularly illustrative. It is a Court of Appeal case, so therefore carrying that extra weight and authority. Now, this was a case where the Court of Appeal was invited to consider the defendant's silence in the face of an offer to mediate. And one of the particularly important points in this case, and I think that it is going to become increasingly the background to these applications, is that there had been a case management order made which had directed the parties to consider ADR throughout the case. And in the event that one party were to raise the issue and the other party to reject the proposal, that within 21 days of that rejection, the rejecting party should file a witness statement detailing their reasons for rejecting. Well, in this case, the claimants did suggest that mediation would be appropriate. The defendants didn't respond and did not file a witness statement. The case did proceed to trial. The claimants were successful, and at first instance, they recovered 70% of their costs. And the judge indicated that he wasn't prepared to increase on that percentage, despite the defendant's approach to mediation. Claimant's legal team appealed that decision, and the Court of Appeal agreed with them. They emphasized the point that you cannot simply sit on an offer and not respond to it. The court underlined the importance of that case management order, and in particular made it clear that if you are going to turn down an invitation to mediate or some other form of ADR, it is important at the time to commit your reasons to writing for the court to consider. The court did note that the request to mediate came quite late in the day. It was a long-running case. The proposal for mediation came about 8 months before the eventual trial. And the Court of Appeal did acknowledge that that would be a factor in determining the costs order. And as a general observation, the court made the point that a refusal to engage in mediation was one of the potential aspects of conduct that the court would be taking into account. Tim.
Thank you, Andrew. Moving on, if I may, we're going to look at a couple of cases where recently, post-Churchill, there has been a successful no to mediation. And again, the caveat is that there are many of these cases to look at, but a census sticks out. And here again, the merits were looked at, one of the Halsey factors, which has been much debated since Halsey. And you will see that there, Constable J considered a refusal to mediate by the party that succeeded at a trial. And he found the refusal was not unreasonable because there was a gulf between the parties. And he thought it was very unlikely indeed that ADR would have been successful. So that's a case going against the flow. What was strange about it was that the judge was not referred either to Churchill or to the 2024 CPR amendments, one of which makes ADR part of the overriding objectives. So very curious indeed that those points were not referred to in court at all, and not referred to in the judgment. And so one should bear in mind, if relying on that case, that there is that question mark about it. Another unpronounceable name, Grzyns, is my best effort, also looked at the merits of the case. And here again, the court recognised the duty to keep under consideration, ADR under consideration throughout the case, but went on to conclude, well, that doesn't compel a party to settle unfounded litigation simply for fear of a cost penalty. And specifically stated, as you see there in bold, the cost penalty should not bite where there are good reasons provided for not mediating. That begs the question, of course, what are our good reasons? And if you look at that case, you will see that the conduct of the party seeking the cost penalty was, to put it mildly, less than exemplary, and was indeed at one stage suggesting mediation should take place immediately, notwithstanding that party had within his possession evidence which the other parties wanted, but he was not disclosing. And so the court looked at that in the round. And I think this starts to give a demonstration of what Andrew referred to earlier on as the nuances of these cases. It's no longer good enough to say, well, we'll mediate, but we'll do it later, or we need this first or that first. There really needs to be a considered and well-crafted set of reasons given, which are likely to persuade the court, and hence my earlier reference to the need to be across the case law. But those two cases demonstrate that this is not one-way traffic, and the courts are looking very carefully at these issues. Coming on to conduct, Part 44 was amended in the 2024 amendments to give teeth to Churchill, and the court was asked to specifically take into account where there was a refusal a refusal to engage in ADR. That is something which should be taken into account when costs were considered. But it is important, I think, and again, looking at the cases in the round, to bear in mind that the single issue of whether or not ADR was refused, it is quite clearly in some cases, but one of the issues which a court will look at. And the multiplex case there is not an ADR case, but it's simply to make the point that when the court exercises its discretion on costs, it will look at the entire conduct of the parties. And I think one golden theme, if you like, which runs through the cases is where the parties are arguing about this issue of whether there should or should not be a cost penalty. The court will look at the conduct of the parties overall. And if there has been poor conduct, that is going to be a very heavy factor, which may mean that the usual outcome on refusal of ADR does not follow the case at all. And the case just discussed, Grzyns, I think, is a very good example of that. Talking of the nuances, and again, I think Andrew has alluded to this, the issues today in court tend to not to be a question of yes or no to mediation, but what about the timing of it, and is now the right time? And I think from a defence perspective and being careful about costs, if there is going to be a form of ADR, particularly if it's going to be ordered by the court, it should be at an appropriate time. And APIA, I think, gives us a look into this, and about how the courts regard the need to engage and timing. So this was not on Part 44 as such. There was a specific order and the parties were ordered by the courts to engage in ADR within a certain time, and if they did not do so, to give written reasons immediately as to why that was. The claimant suggested mediation, and as you see there, the defence response was, expert evidence should be served first, and there the matter lay when it went back to court. And the court said, this was a breach of the previous order, because the order was that the parties should engage in ADR. And saying no because it's too early, because you want expert evidence, was not regarded as engagement. There was an article on Ali versus Channel 5 broadcast by Masood Ahmed on this very same subject, which is also worth a look. Query whether the party refusing mediation in APR could have engaged with ADR by saying, yes, we will mediate. We will certainly give it very serious consideration at the appropriate time, but here are the reasons why we need to see expert evidence to enable us to do that. That is the crux of this question of our title today. How do you say no to mediation? You say it with a great deal of circumspection and with good written reasons to support it. The Grenfell Tower litigation has been very interesting in its use of mediation, and the court there has woven ADR processes into the very complex litigation processes where there are multi-parties, both on claimants and defendants, a very large action. And the issue came up there about the when mediation should take place. And so I think I've trespassed on your ground, Andrew. I think I was supposed to have that. I do beg your pardon. I'm going to pass over to you to talk about Grenfell. I beg your pardon.
I think you were getting close to trespassing, but no harm done. So yes, as Tim started to say, the Grenfell Tower litigation has addressed mediation several times. And it has been really interesting to view this litigation. And there was a hearing in December of last year. Master Cook and Mrs. Justice Jefford, I think it was, that considered whether they should order mediation, as some of the parties were requesting. And the assumption that the judges started with was there would be mediation. That wasn't really the issue. The issue was much more, when should it take place? It was contemplated in this case that the mediation would involve two mediators. It was anticipated that the mediation would take at least a week, and therefore the costs of the mediation were going to be significant. There were many defendants in the Grenfell case. My recollection is 15 defendants, and in addition, a number of Part 20 defendants. Some of those defendants had very deep pockets, and others much less so. And it tended to be those that were less well funded, that were nervous about the mediation at this stage. And they were arguing that they needed to see more disclosure before they felt comfortable in moving to mediation. And by that, they meant comfortable in being able to advise on appropriate terms of settlement. So the court in Grenfell effectively timetabled the mediation for a little way down the line. Interestingly, the court did not fight shy of what in many cases is the sacred cow of the fixed trial date. They looked at the timetable, they agreed that it would be appropriate to mediate and agreed that it was not right yet. And they built into the timetable mediation, and they pushed back the fixed trial date by about 6 months. A really interesting case, well worth having a look at to see how the court addressed in a very mature way the issue of, and in particular, the timing of mediation. A couple of other interesting cases that I thought would be worth looking at. The first case was Mengrani and Mohammed. Here, the court was contemplating ordering a stay for ADR, but the court felt that it was appropriate before doing so to hear from the parties as to what steps were outstanding, so that the court could consider with the parties what evidence would be necessary to allow effective and cost-effective ADR. The second case there of Williams and Seals, again, was contemplating a case where the issues were complex. And it was felt in that case that a mediation, yes, it would be appropriate, but not until the case had been properly and fully pleaded. So two interesting slants on the question of when mediation should take place. One of the themes that appears throughout these cases is that the decision about moving to ADR is not a one-off. This is something that needs to remain at the top of the party's agenda throughout the case. So there is a continuing duty on the parties to consider whether and when ADR should take place. And there are a couple of cases there which are worth looking at, and that includes the Grenfell Tower litigation. It's only a short decision, but well worth a quick read. There is a lot of commentary and a lot of cases that if you are preparing for an application, either in support of or in opposition to an order for ADR, do have a look at the cases. As Tim was saying, it's really important to frame your arguments by reference to the decided cases. And if you take a look in those sources, you will find much more detail. We've just tried to highlight a few of the cases that we think perhaps are most persuasive. It is now all about timing. It is rarely about whether, it's about timing. And the court is going to look at that by reference to the procedural informational context of the case and the sort of issues the court will be looking at. Has liability been admitted, or is it still in dispute? If it is still in dispute, what are the nature of the issues? Now, I don't take that or the second point about causation to suggest that a case where liability is in issue is one that's not suitable for mediation. Indeed, I think it remains very much the case that where both sides are fully informed as to their position and can assess the litigation risk, it's entirely appropriate, and particularly perhaps in clinical negligence cases, where issues of breach, issues of causation can interlock and can when there's lots of moving parts to the case, those may well be entirely appropriate for mediation once there has been sufficient information and expert evidence to allow you to properly assess the strength of your case. If it's on quantum, again, there needs to be sufficient information to allow both sides to properly value the case. That's a long way short from saying that all the evidence that might go into a trial bundle needs to be there, but there must be sufficient information. The court will be interested to know whether a claim has been issued. As Tim demonstrated in one of the early slides, there is an increasing number of cases, or there are an increasing number of cases referred to us for mediation which are pre-issue. So it's certainly not a factor against mediation, but it's something that the court will need to be aware of, and you need to be aware of. Have the parties incurred significant costs? Well, you may recall that this was an issue in the Northanger case that I looked at earlier. The question of mediation wasn't raised until well into the case, when significant costs had been incurred. The court acknowledged that, but pointed out that there was still some way to go. And in fact, there was a further 8 months before the trial, and of course the trial itself, which carried a lot of costs. But it's a question. Are the parties ready, legally, financially, emotionally, for a serious discussion leading to settlement? So it's a question that you need to be having with your clients. In fact, we take the view that this is an issue that you should be having with your clients from the very beginning of the case, talking about how and when the case is going to resolve, so that the question of settlement is there at the top of the agenda throughout the case. And it's acknowledged that each time this is looked at, there will be trade-offs, and the timing does need to align with your client's objectives. In the area where we still are undertaking the majority of our mediations, clinical negligence, sort of objectives that we assure exist with NHS resolution is that NHS resolution make it very clear in public statements that they're keen to continue to improve the resolution of cases pre-proceedings, and the stats, as you can see in the middle of that slide, demonstrate that the NHSR have been doing increasingly well in resolving a much larger number of cases now than they were going back to the beginning of the mediation project, so that the number of cases resolved pre-issue have gone up from 66% to well over 80%. And I think whilst we are focusing on mediation, by looking at mediation, looking at the cases that we've mentioned and others, it'll be interesting to see that mediation is only one method of ADR. And again, by reference to NHS resolution, you will see in their annual report that they are emphasising that they are looking at a whole range of methods of ADR. And I talked earlier about considering ADR to coincide with your client's objectives, and the sort of objectives that we are anticipating from the defendant's side, looking to minimize financial outlay. Can the case be compensated at a sensible sum? If it can be dealt with early, then the costs will be saved. an opportunity to protect reputation and relationships. We're very conscious. We hear from claimants how damaging ongoing litigation can be with someone who is really crucial to their overall well-being, their doctor. Early resolution can help protect that. It can enable defendants to manage exposure to risk in a predictable way. At mediation, you remain in control. You do not give up control to the judge. Can avoid precedent-setting litigation, and of course, it will reduce court time and the backlogs that bedevil the court system at the moment. And it can have a long-term impact in identifying repeat litigation patterns. It can help with internal morale. It doesn't help anybody, and it doesn't need us to tell you that having a case hanging over a clinician for years is damaging to morale. So resolving that early is going to be helpful. So all the sorts of things that will be relevant to the long-term and overriding objectives of defendants. We've given our thoughts, but we're conscious there are thoughts, and we're really interested to hear your thoughts on particularly ADR orders, whether you see them as good things, bad things, what experience you've had in addressing the courts, and would really appreciate some input from yourselves, particularly defendants, but not only defendants, on those issues. So please, anyone with any thoughts, challenges, would be delighted to hear them.
The Q&A remains blank at the moment. We do invite your input. At the last webinar, we had a solicitor and counsel who had just completed 3 cases as a result of court-ordered mediation, and we heard of their experiences from the claimant perspective. So that's one reason why we're interested to balance this up and to get some defendants' views. I'm just preparing at the moment for a mediation on Friday, which is a personal injury mediation, and is taking place because the court ordered mediation. So the subjects that we're raising are not hypothetical; they are real and happening in the courts. Can I ask, have any of you come across, any member of the audience, come across court-ordered mediation so far? Are you prepared to state your experience or your thoughts on that? The Q&A and the chat remain silent, Andrew. So I think we'll move to our discussion and keep an eye on whether any questions or thoughts do come. But I think you've got some thoughts about these matters.
Well, I have. But please, anyone who wishes to contribute, do jump in, because we're much more interested to hear what you have to say rather than to keep hearing from Tim and I. But Tim, we've talked about a number of the cases. In particular, I spoke about the Grenfell case, and that was a case where the court wouldn't order mediation at the time it was being considered. But what was it as simple as that?
Well, I think, as we've said, Andrew, it's not a simple yes or no anymore. I think that anyone dealing with litigation, looking at the cases, can actually take heart from the care and thoughtful approach which is being taken by the judiciary. Clearly, there is a steer from on high, from Churchill, from the CPR amendments, from the DKH case, and I'm aware that judicial training is being rolled out, not with ADR as a subject, but in all judicial training there is a thread of ADR running through it. and the case examples which judges are given during their training sessions. So we are going to see more of it, but it's no longer a question of is it a JSM or is it mediation. The case is looked at in some detail, and I think that's the approach. That's our message, I think, today, that some care and thoughtful preparation needs to go into this question. And if there are good reasons for saying this is a case for trial, or we couldn't really have a good mediation at this stage because information X, which is crucial, is missing, I don't think it's going to be too difficult to get the court on side. But the badge reasons of, no, we don't want to do that, or we prefer this form of ADR or against another, without the reasoning to go with it, is going to give rise to difficulty. And that, I think, is why it's not simply the leaders of departments or firms who need to be aware of this, but the fee earners on the ground who are writing the emails or the letters dealing with these subjects. The cost orders, if they're made, have often involved very large sums of money, and clients will not be happy if there was a cost order because the approach to litigation, the approach to the case was not ADR compliant.
Tim, thank you for that, and I agree with all those observations. I just wanted to interrupt because we have a question that's popped into the Q&A, very interesting question, where the position is put as this: I have a case where there is a court-ordered mediation, but the claimant has just applied for it to be in person rather than remote. And the questioner says, do we have experience of the court making orders as to the format of the mediation? So that's the first question. And then perhaps we could expand that slightly as to whether, Tim, you think there are any benefits between remote and in person. But anyway, the first part of the question is, do we have experience of the court making orders as to the format of the mediation?
I have seen orders where the format was considered. I think, Andrew, and this is, you're closer to home for you than me, but I think it was a Bristol case where the format was considered. And I think the approach generally from the senior judiciary is that the precise form of ADR, and certainly things like selection of the mediator are for the parties rather than the court. And I think on the judicial template, which we've referred to and was dealt with in the last webinar and is available on our website, that template does not deal with that. That said, I can well see that for the reasons we've just been talking about, the court will take a thoughtful approach. And I think if an application is made or the court is dealing with case management, they will look at this. I'll be interested to see what the reasons are for the behind the application that it be in person. I think from a purist point of view, you would say, well, it's always better to meet about these things where possible. But when you look at who's going to be at the mediation and where they're located and the cost of travelling to be at the mediation, and you weigh that against the fact that because of the COVID experience, mediation went online and was very successful online, I think it could be quite a nuanced decision. And I would expect, looking at this very broadly, that the courts will be saying that cases of low to medium value, they probably should be online rather than in person, unless there are pressing reasons. And I think simply saying, well, it's nicer, it's more effective to be in person, standing alone would not be sufficient. So I think the court will stand back. They will certainly not stand back from the type of ADR. They will want discussion on that. But actually, the arrangements, I think the court will stand back from, unless there is a particular application. That's my view. I don't know if you've got any different view to that.
Not significantly, although I think the question assumes that the claimant in this case is asking the court to make that decision. my guess is that the court will be interested to engage in the discussion. And ultimately, I suspect if forced, the court will make a decision. But the sort of factors that you've talked about, and I'm sure proportionality will come into play, and may well be the determining factor. So if it's a low to medium value case, then my sense is the court would be likely to err on the side of an online mediation. Claire, you asked the question. Does that address the issues, or is there anything more focus that you wanted to raise?
I see there are a couple of comments there, Andrew. It's because the claimant prefers it, and Claire says, well, we say it will be incurring costs unnecessarily due to the parties being geographically distant. I'm sure the court will want to look at the question of costs and proportionality, and then against that, are there any special factors? And I think if the strength of the claimant's case is because the claimant prefers it, I suspect if there are proportionality reasons for that not to be the case, I don't think the claimant's preference would overturn that. But that's simply my guess, and we'd have to see what else was said behind that. We talked, Andrew, earlier on about the Grzyns case, and the judge saying, well, you can refuse ADR if there are good reasons. Any further thoughts on what good reasons might look like, and any guidance we can give in broad terms on that?
Well, a number of the previously perceived good reasons have been knocked on the head. Halsey set out a number of potentially good reasons, most of which have now been decided as not good reasons. My sense now is that it probably will be an uphill struggle to argue against mediation period. I think the real issue that's going to concern the court is when is the appropriate time for the mediation. And again, I think one of the determining issues will be when is the mediation going to be effective, because the court are going to want to see costs being used proportionately and effectively. And I think that if you are not keen to mediate, I think framing your argument along the lines of, well, we will mediate, but not now, and the reason that it's not now are X, Y, and Z, then I think that's much more likely to get a favourable hearing from the judge. I think the other thing, Tim, that I would say to that is that, and this does come out in several of the cases, is that what is important is that if you are declining an invitation to mediate, it's important to set out those reasons in full at the time. Don't wait till you're up before a judge explaining retrospectively your position. Get those reasons down at the time, so that the court can look at exactly how you were perceiving your case and what was needed before an effective mediation could take place.
I agree with that, Andrew. It occurs to me, just going back to Claire's question, that one thing in her position I would look at is the judgment you referred to earlier on from Lord Justice Briggs in PGF in the Court of Appeal, and the reasoning there, why a cost penalty was given when there had been silence as against an offer to mediate, was all about proportionality and the economics of the matter. So that I think is something which the court will want to look at in light of such an application. But Andrew, we're coming to a close. If I'm just checking to see whether any further the questions, but I think we can. Just we're waiting to see whether there are any further. I just run on. There's a few slides here of training and so forth that Trust Mediation is offering, and I want to just give notice of the next mediations. This is the draft Churchill mediation order, the judicial template, which is on the Trust Mediation website. It will be in the white book in the next edition, which I think comes out in about April. There is a Churchill orders landing page on our website, and we are rolling out the ADR champion concept, where we provide information of this type in more detail to claimant and defendant firms if they're interested to work with us on that. We've also introduced a new e-learning module aimed particularly at lawyers and claims handlers who have no or little experience of dealing with mediations, and that's a beginner's e-learning module, which is available with our training. So that is wrapping up for today, and confirming that we have 2 further webinars planned. They will probably be, we are still waiting to see, neutral evaluation and new personal injury mediators who we are talking to and adding to our panel. So that's what's coming up next. If you'd like to note those dates, we'll be advertising those webinars in the usual way. Going to the Q&A, we have no further full comments now. Yes, there are four. That completes the questions. So that brings today to a close. Thank you very much indeed for attending. As mentioned, you will be able to get or to refer colleagues to a recording of this webinar, and hopefully you'll be able to return on the 25th of February at the same time. On behalf of Andrew, Trust Mediation, myself, thank you very much. Goodbye.
Bye.